If you asked me to guess which of the services would have to solicit extended testimony about whether or not drinking in the style of a fraternity is part of the culture of the branch, I have to tell you I would not guess that it was the Air Force. I would guess that it was the branch that was literally founded in a tavern while hopped up on frustration with tea tariffs. Instead of General Washington leading troops to win American independence, the branch he couldn't possibly have dreamt of gave rise to a Lieutenant Washington, who has spent the better part of a decade bouncing around between the Air Force Court of Criminal Appeals and the Court of Appeals for the Armed Forces in a case heavily related to his ability to control his alcohol consumption. When the Air Force advises its members to aim high, I don't think they meant high courts. This is Conduct Unbecoming. I'm Erin, and I'm your host. First Lieutenant Jamal Washington commissioned into the Air Force by way of ROTC. He PCS'd to Malmstrom Air Force Base in Montana in November 2015, working initially as a flight commander overseeing security operations. Later, in August 2017, after 2 years at the base, Washington changed billets and began to work as a convoy commander working on the Convoy Response Force. His leadership team was composed of himself, 1 or 2 senior non-commissioned officers, several E6s and E5s. The rest of the team consisted of junior enlisted airmen below the grade of E4. Shortly after Washington took charge of his team, he began socializing with the junior enlisted airmen that worked for him. This wasn't the occasional unit barbecue either, but rather weekly hangs in their homes during which Washington drank with them, as well as off-duty overnight trips out of town and out of state. I don't think this kind of event, this hanging out and getting drunk, is uncommon for the age group, and these hangouts predictably involved horseplay and encouraging one another to drink. Some of the junior airmen expressed feeling discomfort because they knew and understood that officers, especially those in leadership positions, weren't supposed to be hanging out like that with enlisted personnel. During one drunken party at a subordinate's home, the host mentioned to Washington that he wished he could attend a boxing match in Las Vegas. In response, Washington purchased airfare and accommodations for himself, 2 of his subordinates, and 1 of their wives, ostensibly with the understanding that they would pay him back. He even purchased new airfare after a change in schedule. Washington also allegedly told the 2 that when they submitted their leave requests, they should lie and say that they were traveling to Salt Lake City instead of Sin City. Apparently, Washington didn't want others to know about the trip because it was not generally acceptable for lieutenants to go on personal overnight out-of-town, out-of-state trips with junior enlisted airmen and staff NCOs. Planning ahead really didn't seem to be anyone's forte because after the 4 of them arrived in Las Vegas and checked into their shared single hotel room, they discovered the boxing match tickets ran for thousands of dollars, so instead they attended a comedy show. They spent the rest of their time in Las Vegas drinking. This wasn't the only trip that Washington took with a subordinate. He traveled to both Billings, Montana and Spokane, Washington with one of his subordinate airmen. When they traveled together, they shared a hotel room. For his part, Washington asserted that he thought drinking with his subordinates did not affect good order and discipline in his unit because he sometimes saw other leaders at the base drinking with their enlisted personnel, both in town and on base, at the club. And it bears mentioning that an on-base club is just a bar. I've seen them attached to a Denny's. To support his claim, Washington introduced photographs of officers and enlisted personnel socializing and drinking in a home, at a bar, and standing outside a party bus. His photos implicated other officers in leadership positions, sort of an "if I'm going down, I'm taking them with me" approach. He did admit that he knew his trips with subordinates might be viewed disfavorably, but as he understood it, his unit was very cohesive, morale was high, and they were always joking around. According to Washington, he'd bought his unit Christmas presents and treated them like his family. And I think maybe he's a little bit right, but more in the fraternity brother sense and less in the biological family sense. Perhaps I'm the cheese that stands alone on this, but I've never had much interest in drinking to the point of rambunctious drunkenness around my parents or grandparents. I'd say sorry to my mom and dad since they listen, but I don't think they want that either. And for whatever it's worth, the armed services seem to hew more closely to my preferences. Proving fraternization at a court-martial requires testimony as to the socializing customs of the relevant service. It's like having doctors in a medical malpractice claim testify as to the standard of care. Here, another airman was invited to weigh in and was asked, "Is it a custom of the United States Air Force that officers shall not fraternize with enlisted persons on terms of military equality?" I mention that mostly because I think it's really funny to picture government counsel sitting in a war room running through candidates for the testimony, needing someone who is not a social butterfly that flaunts the rules, but also needing to avoid a stick in the mud who spends no time with their colleagues and whose social strategy would come across as unbelievable and isolationist. It seems a really delicate balance to strike. Here, it actually seems government counsel hadn't addressed custom in their case in chief and used a defense witness to establish that the custom and tradition he experienced, starting with his time in ROTC, was that officers were not supposed to go out drinking with enlisted personnel and otherwise fraternize. Washington's trips and hang sessions became, as the court described later, a matter of official concern. Buried in the opinions, it seems like there were multiple airmen that came forward with claims about inappropriate sexual advances, and that those reports sparked an investigation generally into Washington. As military investigators began to dig into his extracurricular activities with his subordinates, descriptions of behavior more troubling than prohibited fraternization began to bubble up during interviews. The investigation led to someone we'll call Carl, a second lieutenant tasked with shadowing Washington during an annual training trip. Washington and his colleagues drove to the week-long training, as best I can tell, which necessitated spending the night at a hotel along the way. And as one does when tasked with driving long distances on official government business and surrounded by those who report directly to them, Washington drank heavily. They all did. They drank until the bar shut down for the night. That night, Washington grabbed a man's penis twice through his clothing by first, quote-unquote, nut-tapping him, and later grabbing his genitals and betting the man $100 he wouldn't use his penis that night. Washington also touched Carl's genitals, either over or under his clothing, while the two were in Washington's hotel room. Carl described being very intoxicated and having little memory of the van ride back to the hotel where the group was staying. Carl remembered being in the hallway talking to someone and remembered Washington inviting him into his room, saying he needed to tell him something. Carl described sitting on the bed and, at defense counsel's inquiry, admitted that he sat there even though there was a chair available, something I think most people do in a hotel room. Carl testified that in the middle of their conversation, Washington leaned forward and kissed him on the lips. He explained that he was confused because, as he understood it, they were just friends. Washington then reached into Carl's pants and touched his penis, though Carl couldn't remember if it was above or under his underwear. After the touching, Carl said he remembered telling Washington that he was not interested in him, that he wasn't interested in that he wasn't interested in anything like that. And later, Washington still repeated his actions, kissing Carl and putting his hands down his pants. Carl testified that he declined Washington's offer of oral sex, that he made it clear he did not want to engage in sexual acts with him. Carl said he found it difficult to react to Washington's advances because of his intoxication level, but he nevertheless made his way out of the room and later told his girlfriend that night about Washington attempting to kiss him and touching him in an inappropriate way. He said he needed to talk to someone and he felt comfortable disclosing to her. To hear Washington describe it, he didn't touch Carl, or rather, hadn't committed abusive sexual contact. It's a little unclear from the record which of those two arguments he relies on. Instead, Washington said that he and Carl engaged in a progression of mutually consensual sexual contact. He said that while the two were in his hotel room, Carl disclosed that both men and women had hit on him before. It should go without saying that being hit on by a man previously doesn't give another man the right to touch someone's genitals without their consent. This very much feels like a scenario in which reversing Carl's gender highlights the absurdity of the argument. Just because a woman has absolutely been hit on by some man somewhere does not mean that future men are entitled to grope her. To the extent you worry that a panel would be harsher to Washington because the charges were based on his apparent sexual preference towards men, yeah, same. For what it's worth, the military judge instructed the members that, quote, "You may not consider homosexual conduct in a more aggravating light than heterosexual conduct for purposes of determining whether the accused's conduct was wrongful and dishonorable, unbecoming of an officer, service discrediting, or prejudicial to good order and discipline." As with most courts, military courts presume a properly instructed panel behaves in accordance with those proper instructions. It became a central issue whether Washington could introduce evidence of Carl's supposed alleged sexual predisposition towards men and any other previous sexual behavior. The defense wanted to admit some form of evidence, believing that Carl had a sexual history with men that went to his consent during this incident. The military judge held several motions hearings to determine whether that evidence was relevant and therefore admissible, believing Military Rule of Evidence 412 was implicated. Rule 412 is the military's rape shield law, which generally prohibits the admission of a victim's past sexual behavior or predisposition in sexual assault courts-martial. It's to keep the focus on the incident at issue, not to put the victim's sexual history on trial to potentially orient the panel against them. The military judge gave the defense two options. Washington could submit to cross-examination in a closed session, a session without the panel, so the judge could decide whether an exception to Rule 412 applied, or the judge would instruct the panel to disregard Washington's testimony about Carl's sexual predisposition and previous sexual behaviors. Both options sucked for the defense, so they rejected them. Although defense counsel had prepared and filed a motion indicating they intended to offer evidence of Carl's previous homosexual experiences, not just being hit on, they abandoned that path because they, quote, misunderstood some of the facts. That's how we ended up with just Washington's testimony that Carl said he'd previously been hit on by both men and women. At court-martial, the military judge also struck Washington's testimony as to the alleged consensual circumstances of his interaction with Carl in the hotel room. At general court-martial, the panel convicted Washington of one specification of abusive sexual contact for the incident with Carl, one specification of conduct unbecoming for twice grabbing the genitals of one of his subordinates, and 5 specifications of fraternization. They acquitted him of 3 other specifications of conduct unbecoming and sentenced him to dismissal. Washington's first appearance before the Air Force Court of Criminal Appeals resulted in 3 separate opinions and 78 pages of legal writing. That's especially impressive because it meant that every single judge on the panel wrote an opinion. Washington's appeal argued 5 errors, 3 of which the AFCCA addressed. He argued that the evidence was factually and legally insufficient as to fraternization, that the military judge abused his discretion when he struck Washington's testimony, and that there was excessive post-trial delay. The AFCCA set aside all 5 convictions for fraternization, 4 of them with prejudice, 1 of them without, but affirmed the findings of guilt as to the abuse of sexual contact and conduct unbecoming. They relied heavily on the cross-examination of that defense witness who testified as to whether or not it was customary in the Air Force for officers to fraternize with enlisted personnel. The cross was, probably correctly, conducted by civilian defense counsel and carved out just enough space for Washington to slip through. Counsel sought to separate what rules the witness held himself to from the actual Air Force customs. There, the witness sort of floundered, or, depending on your position, excelled. He said there was a laundry list of things an officer should not do, things that were definitely prohibited fraternization, like living together and getting involved in certain financial things. But when it came to the consumption of alcohol with subordinates, the witness kept returning to his personal experience and opinions. He said he was probably more stringent, that there was a spectrum, that he didn't really drink anyway. But he said there was a by-the-book answer. A by-the-book answer it doesn't really sound like he gave. He explained that interactions were probably fuzzier for young officers given age similarities and the pressure to be a good leader. That officers and leaders should also always be professional, but that professionalism is a spectrum, and every officer was therefore different. Or, to boil it down, that there wasn't really a custom. In spite of these fuzzy answers, the panel had convicted Washington for violating Air Force customs through fraternization, and the AFCCA decided there wasn't sufficient evidence as to what those customs were, as to when behavior crosses from acceptable socialization to unacceptable fraternization. So there's nothing to support the convictions. And that opinion is probably a lesson for defense counsel on weaknesses to look out for at trial, and to government counsel on actually preparing a witness to testify as to the custom of not spending every weekend drinking and roughhousing with subordinates. And this is a slightly frustrating outcome because, sure, it's probably a spectrum and yes, there are gray areas, but Washington's actions don't seem to fall into the gray areas. This isn't an officer drinking with subordinates at a military ball or a wet town. It's not the occasional holiday party or wedding. It's a weekly casual hang where subordinates are routinely seeing their boss drunk and traveling in their free time to see their boss drunk in fun new locations. On the other hand, government counsel has the burden and failed to prove up the custom that every member of the panel was probably aware of. I think that's what makes it so frustrating. This isn't some niche rule that a panel would need explained to them. It was a custom that each of them interacted with daily. And maybe it's more like Chief Justice Stewart's definition of obscenity. We can't really define it intelligibly, but we know it when we see it. As to the question of whether the convictions for conduct unbecoming and abusive sexual contact were factually and legally sufficient, the AFCCA answered in the affirmative. They also declined to upset the apple cart regarding the rulings the military judge made around the MRE 412 issue, concluding the judge did not abuse his discretion in excluding the supposed evidence Washington had to offer, in offering the defense those 2 options, or in striking portions of Washington's testimony. The convening authority later determined that a rehearing for that hanging chad of a fraternization specification was impractical and therefore dismissed it. They ordered a rehearing on the sentence for conduct unbecoming and abusive sexual contact. A new panel of officers sentenced Washington to 9 months of confinement, forfeiture of all pay and allowances, and a reprimand. Washington again appealed, asserting 9 additional errors. The AFCCA issued another 48 pages, ultimately modifying Washington's sentence to forfeiture of $2,500 per month for 6 months. They gavel-gavelled and affirmed the sentence as reassessed. The AFCCA touched this case at least 3 times before it wound its way to the Court of Appeal for the Armed Forces. CAF granted review to determine whether the military judge erred in striking Washington's testimony and concluded that he did. The majority reversed the AFCCA as to the specification of abusive sexual contact. Specifically, CAF concluded the military judge applied an erroneous view of MRE 412 as to both the uncharged conduct evidence and Washington's testimony about what Carl allegedly said in the hotel room, and, perhaps more egregiously, that striking Washington's testimony violated his Sixth Amendment right to testify in his own defense. The government couldn't show that the error was harmless, so CAF had to unwind the conviction. In coming to these conclusions, CAF determined that the testimony Washington offered was not sexual predisposition evidence, but rather that Carl had a girlfriend and had been hit on by men and women before. The AFCCA had taken Washington's statement that, quote, "At the time we were talking about different preferences," and concluded the testimony was going somewhere forbidden, but that Washington hadn't actually testified as to what those preferences were or supposedly were, and hadn't violated MRE 412. So CAF reversed the conviction for abusive sexual contact and kicked the case back to the AFCCA for a 4th look. I'm sure they are delighted. Thank you for listening. If you enjoyed today's episode, please share it. I invite you to submit case suggestions and feedback to conductunbecomingpod@gmail.com or on conductunbecomingpod.com. Join me next time when we leave this man named Washington for the state of Washington. Until then, take care. Conduct Unbecoming is a podcast where I get to talk about interesting crimes and cases that involve U.S. military service members. I research, write, and produce the podcast myself. The opinions expressed are my own, and perhaps it's obvious. Conduct Unbecoming is not approved, authorized, or endorsed by the Department of Defense.